Good day. I am Lady Mae Patac from BSHM 3A. And now I am going to discuss the law on obligations and contracts. This topic tackles the different articles and which we can be seen in the screen. So before we dig into our discussion, let us first know what does obligation and contracts means. So when we say obligation, refers to a legal or moral duty, a binding commitment, or a responsibility to perform a certain action. It implies a sense of being bound by law, contract, promise, or ethical consideration to fulfill specific obligations. Failure to meet these duties may result in legal consequences, penalties, or the breach of trust or agreement. A contract, on the other hand, is a legally binding agreement between two or more parties that creates an obligation to do or not to do a particular thing. For a contract to be valid, it typically requires an offer, acceptance, consideration, legal capacity, and legality of purpose. So let's proceed and dig into the different articles. For the obligation, Articles 156, an obligation is a judicial necessity to give, to do, or not to do. The term judicial necessity signifies that an obligation is not merely a moral or social duty but has legal significance. It implies that the obligation is enforceable by law and failure to fulfill it may lead to a legal consequences. To give, to do, or not to do. This part of the definition categorizes obligations into three main types. To give or dare. The obligation involves the delivery or transfer of a specific object, offer referred to as thing in legal terms. To do or favor. The obligation requires the performance of a specific act or the provision of a service. Not to do or non-favor. The obligation entails refraining from performing a particular act. In conclusion, Article 1156 of the Civil Code succinctly captures the essence of obligations in the legal context, emphasizing their enforceability, categorization, and the broad scope of situations where obligations may arise. It serves as a fundamental principle guiding legal relations in the Philippines. Next, Article 1157. Obligation arise from law, contracts, quasi-contracts, act or omission punishable by law, and quasi-delicts. So in conclusion, Article 1157 serves as a cornerstone in understanding the diverse origins of obligations, providing a comprehensive framework that is crucial for legal practitioners, scholars, and individuals navigating the legal landscape in the Philippines. So we have here the classification of obligations. First, we have the primary classification of obligation under Civil Code, pure and conditional obligations. Article 1179 to 1192. Pure obligations are those not subject to any conditions, while conditional obligations depend on an uncertain event. Obligations with a period, Articles 1193 to 1198. Obligations with a period involve a specified term or period within which the obligation must be fulfilled. Alternative, Articles 1199 to 1205. Alternative obligations offer multiple ways or options for fulfilling the obligation. The debtor can choose which of the alternatives to perform. Joint and solidarity obligations, Articles 1223 to 1225. Joint obligations involve multiple debtors, each responsible for his share of the obligation, while solidarity obligations hold each debtor individually responsible for the entire obligation. Obligations with a penal clause, Articles 1226 to 1230. Obligations with a penal clause include a stipulation imposing a penalty in case of non-compliance. The penalty serves as an additional incentive for the debtor to fulfill the obligations. Next, we have the secondary classification of obligations under the Civil Code. We have the unilateral and bilateral obligations, Article 1169 to 1191. Unilateral obligations involve a single act of performance by one party, while bilateral obligations require performance from both parties. Articles 1169 to 1191 elaborate on the characteristic and rules governing unilateral and bilateral obligations. We have the real and personal obligations, Articles 1163 to 1168. Real obligations are those that involve the delivery of a specific object, while personal obligations require the debtor to perform a certain act. Civil and natural obligations, Article 1423. Civil obligations are enforceable by law, while natural obligations are moral or ethical in nature and lack legal enforcement. Article 1423 distinguishes between civil and natural obligations. Next, we have the legal, conventional, and penal obligations. Articles 1152, 1159, and 1161. Legal obligations arise from law. Conventional obligations result from agreements or contracts, and penal obligations involve obligations with a penal clause imposing a penalty in case of non-compliance. Proceeding to the next topic, which is the modes of extinguishing obligations. The law Articles 1231, obligations are extinguished by the payment or performance. The primary and most straightforward mode of extinguishing an obligation is through the complete fulfillment of the obligation, either by delivering the thing due or by performing the required act. 2. By the loss of the thing due. If the specific object or subject matter of the obligation is lost or ceases to exist, the obligation is extinguished. This applies to obligations involving the delivery of a specific thing. 3. By the condonation or remission of the debt. The creditor may choose to forgive or remit the debt voluntarily. This act of condonation extinguishes the obligations, releasing the debtor from the duty to repay. 4. By the confusion or merger of the rights of the creditor and debtor. When the rights of the creditor and debtor are combined or merged in the same person, the obligation is extinguished. This typically occurs in situations where the creditor and debtor become the same legal entity. 5. By compensation. Compensation involves the offsetting of mutual debts between two persons to the extent that they cancel each other out. When compensation is legally established, it extinguishes both debts. 6. By novation. Novation refers to the situations of a new obligations for an existing one, with the intent to extinguish the old obligation. It involves a new agreement between the parties, resulting in the discharge of the original obligation. Now let's tackle the constructs. Articles 1305. A contract is a meeting of minds between two persons whereby one binds himself, with respect to the others, to give something to render some service. 1254A. Articles 1305 emphasizes the consensual nature of contracts, emphasizing that a contract is formed when there is a meeting of minds. Regardless of whether the agreement is in writing or not, this article provides a foundational definition of a contract, forming the basis for understanding contractual relationships and obligations in civil law. The concept of one binds himself with respect to other highlights the mutuality of obligations, an essential principle in contract law where both parties must be bound by the terms of the agreement. By acknowledging the possibility of giving something or rendering some service, the article recognizes the diversity of contracts, encompassing various types and forms of agreements. In conclusion, Article 1305 encapsulates the fundamental elements of a contract, emphasizing mutual agreement, voluntary commitment, and the diversity of contractual agreements in the legal landscape. And that ends my discussion. Thank you and God bless.